afternoon, everyone. Thank you very much for being with us for this afternoon's panel discussion on the application of AML and CTF rules to our legal profession, something that I know is very close to Juliana's heart and Fiona's as well, and something that we're working hard on at the Law Society. I'd like to begin by acknowledging the traditional custodians of the land on which we meet, the Whadjuk people of the Noongar Nation, and pay my respects on behalf of everyone here to elders past and present, and also to anybody here with Aboriginal or Torres Strait Islander heritage today. For those of you that I don't know, and I think I know most of you in the room, my name's Wellington. I'm the CEO of the Law Society, and I'm very pleased to be joined this afternoon by our two guest speakers, Juliana Warner, who's the President of the Law Council of Australia, of which the Law Society of WA is a constituent body, as well as Fiona Halsey, Director of Halsey Legal Services. Just to introduce my fellow panellists before we kick off this afternoon, Juliana is a former partner of Herbert Smith Freehills, which is why we thought it was really appropriate to be here today. With over 30 years' experience in disputes, including in relation to AML and regulatory matters in her practice. She was the President of the Law Society of New South Wales in 2021, having previously been the Chair of their Diversity and Inclusion Committee and their Litigation Law and Practice Committee, as well as serving as a member of their Fidelity Fund Management Committee and Professional Conduct Committee. Juliana became a Director of the Law Council of Australia in 2020, and she is also a member of the Legal Services Council and the Law Admissions Consultative Committee. So plenty of time on your hands, Juliana, for thinking about AML. Fiona Halsey commenced her career in funds management before qualifying as a solicitor. When she first qualified, she worked in-house at EY in Perth. In 2000, Fiona established Halsey Legal, and she now practices almost exclusively in financial services law, including AML and CTF matters, and she's a certified anti-money laundering specialist. Along with her many other governance roles, Fiona is a member of the Law Society of WA's AML and CTF working group, as well as our education committee. So for today's session, we will start with a presentation from Juliana about where we are at the moment with the introduction of the AML regime to lawyers, following which Fiona will do a bit more of a deep dive into some of the practical aspects that we will need to grapple with over the coming months before the introduction of the regime. We'll then make sure there's plenty of time for questions at the end, so please do save those up. And we're aiming to wrap up within about 90 minutes. Make sure you get your 1.5 CPD points if you stay till the end of that period, so that we've got some time at the end for drinks and nibbles before you head home. Just a reminder, I'm sure you've all remembered, but to put your phone on silent if you have one with you. And also a reminder that this session, in terms of any questions in particular, will be run under Chatham House rules. At the close of the presentation today, we will just be checking with if there's anyone in the room who would like to keep their questions confidential, please let us know because we will be recording the main part of this session for our AML part of our website so that others can view it as well. So on that note, I'll hand over to you, Juliana, to kick us off. Thank you.
All righty. Well, I might start up here until I get tired and then I'll sit down. Can everybody hear me?
Yep.
Righty-ho. So, front page, maestro, next page. This is what I'm going to run through today. But before I start, of course, I would like to acknowledge the traditional custodians of the land on which we meet and pay my respects to elders past and present, and to acknowledge that their continuing connection to land and sea. So today I'm going to talk about what I've been doing for the last 12 months. I finished as a partner at Freehills on the 1st of July, almost a year ago, and I expected to take a 6-month holiday before starting as Law Council President on the 1st of January. Well, the holiday didn't happen because within a matter of days, the whole anti-money laundering legislation started bubbling along, and I've been working flat out on that ever since, as well as youth justice, the disgraceful rates that legal aid solicitors are paid, AI in the courts, the international problems around the undermining of the rule of law and criticism of judges in all kinds of international jurisdictions, and a few other things like that. AML is pretty much what I've been focused on. So the regulation has been around for a while. Next place, please. It's been around for a while. Tranche 1 is basically finance companies, banks, and the gambling entities. And it was intended that tranche 2 would be brought in shortly thereafter. And tranche 2 is accountants, real estate agents, lawyers, and jewellers, of all people. So why we're connected up with jewellers is beyond me. But in any event, that was supposed to happen fairly shortly after tranche 1 came in. There was a very long transition for bringing in the actual regulation of the Act. And in fact, I think it's fair to say that the banks didn't really take it seriously because they thought, oh, well, there's this regime here and we'll do the best that we can under difficult circumstances, as a former partner of Paul D. Evans and mine used to say, the late great Peter J. Perry. But AML compliance is hard, and the banks sort of put in a lot of effort but didn't really get it set up. And the gambling companies didn't either. So what happened to kick it all along was that a crowd called FATF, which is a Financial Action Task Force, which is an international body, doesn't have any sort of statutory backing, but it has an enormous amount of influence internationally. And they have developed a series of recommendations about what you have to control money laundering. And by virtue of an agreement between all of those who participate in the FATF sphere, if you don't comply with all of those regulations or you don't comply with those recommendations, FATF can do things like grey list you or blacklist you. That is a very bad place to be because it means other countries won't trade with you, or they'll be very careful about trading with you. So it can have some real economic significance. So in 2015, FATF reviewed Australia's regulatory regime and decided it was average beyond belief. And in particular, they criticised the fact that there were no prosecutions. 6 weeks later, AUSTRAC started proceedings against Tabcorp, and that was the first of the AML cases, and I did that one with some other guys from the Sydney office. And it was a particularly unpleasant set of proceedings because AUSTRAC had gone from being not a very active regulator to absolutely they'd seen the light, and they were just after, people who were money laundering. And that matter was resulting in a penalty of 45 million, which sounded like a lot of money until they moved on to CBA. And there was 700 million there, and then Westpac 1.3 billion. So I did some work on each of those matters. And the 1.3 billion figure is much more consistent with the kind of results that happen internationally from money laundering prosecutions. The fines are astronomical. So in any event, the bank's now taken an enormous amount of attention, paid an enormous amount of attention to their money laundering systems, and they spend millions and millions of dollars on keeping them up to date. So that brings us to the next slide, which is the tranche 2 reforms. FATF is coming to visit at the end of next year. And this has been the motivator for the government bringing in the AML CTF tranche 2 reforms, because one of the things that is required under the FATF recommendations is that lawyers, accountants, real estate agents and jewellers are regulated under AML legislation. Law Council traditionally had opposed the tranche 2 regime because we are extremely highly regulated as a profession already. And we didn't see that there was a lot of point in having an extra layer of regulation on top of that. But in any event, I'll get to that in a minute. So the Act actually went through at the end of last year. There's a funny story about how it got through. Liberals didn't support it. This was in the Senate. The Liberals didn't support it. None of the Greens supported it until they were offered $500 million to agree to 32 pieces of legislation going through on the last day of the sitting in the Senate last year. And then there were two senators who were supposed to be in the chamber, but they weren't. Senator Hanson had a go at Lydia Thorpe. Lydia Thorpe stormed out. She was then expelled from the chamber, and Pauline Hanson went home in a huff. Because they were two down, the government got this legislation through by one vote, which is an odd sort of position to be in. But anyway, it is what it is. There's a phased transition ending on the 1st of July, and the penalty and investigations regime is pretty significant. Bearing in mind that the tranche 2 reforms will basically apply to small business and not big banks, the penalty regime can be really life-threatening. It's an existential threat for firms. The way it is structured is it will integrate with the existing Act. It's very difficult to read. And you really have to get hold of what's called the compilation Act to be able to understand what it's going to look like. It was a real nightmare to try and get on top of it. Next slide, please. I'll tell you about the vulnerabilities analysis. This is what really changed Law Council's mind about its position in relation to this legislation. We got an independent analysis done by an expert from New Zealand, so from outside Australia. And it was a really good piece of work. And what it was designed to do was to show where the issues were in relation to money laundering in the legal profession. And what that actually turned up was that instances of deliberate misconduct were pretty rare. Instances of unwitting conduct, facilitating money laundering, were a bit more common. But the real problem was an inadequate understanding throughout the profession at all levels of what actually money laundering is and how it can be perpetrated and how you can facilitate it without understanding it. So the position of Law Council really changed to be supportive of the legislation as such, provided it came in a form which was tailored for the profession and took into account the unique nature of our profession. We made a number of submissions, and we had a lot of consultation with Attorney General's Department and with AUSTRAC. by which I mean they sat there and we talked at them and they didn't listen, which was a less than enjoyable experience. But we raised a number of problems with the way that their concepts were being put forward. We did not see a draft of the legislation before it was actually tabled. And that was a real problem because, as we all know, the devil is in the detail and is a very, very complex and difficult act to understand. And there are some major problems with it, which we are now trying to fix in the rulemaking process. We did, however, get a couple of really big wins along the way. One of the things that you have to do as part of the money laundering is the AML CTF regime, is as well as all of the compliance activities, which cost a great deal of money. You have to make suspicious matter reports, and the circumstances around suspicious matter reporting are very problematic for lawyers for obvious reasons. But we managed to get a concession from the government, and this is reflected in the legislation, that if the entirety of the knowledge that you have that is the basis for you, the formation of your belief that a suspicious matter has occurred, if that is all privileged, you don't have to file a suspicious matter report. Big win. If it's part privileged, part not privileged, you have to file an SMR. And there's problems around that. And there are also problems around what happens next, but I'll talk about that in a moment. The other big exemption that we managed to get was in relation to barristers. Basically, we said it doesn't make sense to us that barristers who are instructed by solicitors should have to do client due diligence and undertake all these compliance activities. That's really daft. The government agreed. However, the exemption for barristers actually doesn't go nearly far enough. So it's not true that barristers are exempt. It's only when they're being instructed by solicitors that they are exempt from compliance with the Act. So, phase transition. Immediately the Act passed at the end of December. The Schedule 9 investigation powers came in. They're similar to the powers that ASIC and the ACCC have, but worse. And there's even one area where there's been a complete abrogation of the privilege against self-incrimination, not in relation to everything, but in one small matter. The other thing that the Act did immediately was, and this was a boo-boo, it repealed the Financial Transactions Reporting Act. That was the Act that had been in place for ever and a day. It said if you get $10,000 in cash from a client, you must report the $10,000 that you've received. That was abolished, and it doesn't come in again until the 1st of July next year, when the rest of the Act comes completely into force. And I actually raised this with the Austrac CEO and said, did you know? And no, they didn't. And I said, well, what are our solicitors supposed to do? In the interim, when someone brings in a brown paper bag with $10,000 in cash, what are they supposed to do? There's no one to report to. And they sent us some correspondence that said, thank you for bringing this to your attention. We understand that you won't be able to tell us, your profession won't be able to tell us about this until the 1st of July because you've got your confidentiality obligations, but people don't need to back report. So they just sort of had to accept that with good grace. On the 31st of March next year, this year, the tipping off offence was changed. Now, I'll talk a bit more about what tipping off is all about in a little while. But in short, if you file a suspicious matter report, you can't tell anyone. And that was pretty much an absolute obligation until the 31st of March. Now it's you can't tell anyone if you think that disclosure may prejudice an investigation of an offence. But since the investigation doesn't have to have actually commenced, how on earth would you ever figure out whether telling someone is going to influence some non-existent investigation or not? So I don't think there's a lot of practical difference, but Austrac thinks there's a lot of practical difference. On the 31st of March next year, we have to have AML programs. We need to start enrolling in as reporting entities with Austrac from the 31st of March. We have to start developing programs by the 31st of March and onwards, but they don't have to be in effect until the 1st of July. And some client due diligence starts on the 31st of March next year. On the 1st of July, the entire regime comes into effect, unless it gets deferred because people haven't had enough time to prepare, which is possible. The banks don't think that they will be ready, and I'm not sure that the profession will be ready, but we have to try and do the best that we can to do that. And from the 1st of July, there are certain changes that come through in relation to client legal privilege, which are this, sort of reporting of half the, if a suspicious matter report is based on part privileged, part non-privileged material. There's a special regime coming in for disclosure of the non-privileged material, but we haven't seen what it is yet. So, Next slide, please. What does the Act apply to? It applies to designated services. It applies to practitioners and their firms where they provide a designated service in the ordinary course of their business. So the first obligation is to determine whether your practice is captured. So key question, do I provide a designated service? If yes, get your checkbook out because the AML Act will apply to you. If no, take yourself on a holiday to Fiji, but that will be very, very few of you, frankly. Pretty much the entire profession is going to be covered by the regime because of the scope of designated services. Moving on to what is a designated service. It's set out in Schedule 6, Table 6, or Section 6, Table 6. And when you run through that list that's up on the screen, you'll see buying and selling of real estate, managing client money, think trust accounts, management of bank savings or securities accounts, then organisation of contributions for the creation, operation or management of companies, think everything your corporate partners do, creation, operation or management of legal persons or arrangements, and buying and selling of business entities. So that's pretty much all commercial law is going to be covered. Next slide, please. Acting as a formation agent of legal persons. Well, I don't know what that is, but if you do it, you'll be caught. Arranging for or acting as directors of a company, etc. Providing a registered office, business address, etc. Acting as a trustee of an express trust and acting as a nominee shareholder. Now, there's a trick with all of this. There's an extended definition. It's called assisting with the planning or execution of a transfer of property or financial assets. The problem with that is that the Explanatory Memorandum says that merely giving advice is not a designated service. But where does merely giving advice become assisting with the planning or execution of a transaction? We have had many discussions with Austrac about this, and we had many discussions with Attorney General's Department about this because we said, we don't understand it. You need to tell us what this means. We need a bright line. And we have, in fact, put a submission forward to AUSTRAC for an exemption in relation to our bright line. And the point of doing that was not because we thought they'd give us an exemption, because they won't, but to spark discussion about it, because it needs to be clarified. People need to know what they're doing. You need to know when you're providing a designated service. And it's important because if you're not providing a designated service, you don't have compliance obligations. AUSTRAC has finally figured out that they needed to get legal advice about this. So that's what they're doing at the moment. And in fact, I'm chasing them up about whether they've laid an egg on that or not this week. But it's a really big issue because it's sort of key to everything. So moving on, exemptions. There are some exemptions to the scope of the regime that are set out in the legislation itself. For example, I mentioned trust accounts a bit earlier. If the only use of the trust account is for the receipt of fees and disbursements for a matter that you're running, it's not a designated service. Well, what if, in the unlikely event, the client pays you more than the estimated fees and disbursements? Can you pay the client back? Answer, no. Paying the client back is a designated service. So, of course, I withdraw that. Yes, you can pay the client back, and you must pay the client back in accordance with our trust account legislation, but it will be a designated service if you do pay the client back. So there's all kinds of stupid twists around some of this kind of stuff. So the other particular exemption that's actually set out in the legislation is the one around court orders, and this one is even more goofy because the explanatory memorandum reads as though, and in fact the first discussions with AGD put forward this as a proposition, that if the transfer of property is occurring because of a court order, well, that's not a designated service because where's the money laundering risk if there's been a judge all over this? But when you think about that a little bit more, what about what happens before the court order? That's when all the services occur. Court orders at the end of the process, not the beginning of the process. So an exemption for court-ordered transfers is really almost illusory. And AUSTRAC understands the point that we're making, and they're trying to figure out what the story is around that. That's of significance, for example, if you are running litigation which might have a property element in it. Don't for an instant think that just because you're litigating that you're not doing a designated service. You could be if there's a property element involved in it. But the transfer of the property might not happen until the end of the process and not at the beginning. So that is something that we've asked them for an exemption, that if it's anticipated or if it's expected to be, or if proceedings have been commenced, then you don't have to it's seeking a court order, that it's not a designated service. But so far they're dancing around about that one. That has significance for anybody doing family law, because it means that all family law practice that involves any kind of property issue, that's many of them, will be a designated service. And one of the things that the explanatory memorandum was suggesting was that family law practice would be excluded. Wills and estates practice is probably excluded, provided that as part of the wills and estate practice, you don't actually do a power of attorney, because a power of attorney is a designated service. And that seems a bit daft, because I understand in wills and estates practice you regularly do powers of attorney, the people control of assets, you know, the loss of capacity and things like that. So nobody's really in the clear. Anyway, that's that bit. Next page, please. Barristers, yes, my favourite. This really annoys the barristers that they did get an exemption for services provided on the instructions of a client. But what happens if they're briefed by government? Are they exempt? No. What happens if they take a direct access brief pursuant to a court referral for, you know, a litigant, an unrepresented litigant? Are they exempt from the Act? Answer, no. And that's going to have significant consequences for closing down those kind of services, because I don't know that too many barristers will be prepared to undertake any kind of designated service because the compliance costs are too difficult, and the regime is too difficult. So we have been seeking exemptions from AUSTRAC about that as well, to try and make it a bit more manageable for how justice actually works in this country. One of the concerns that I have about this is that it's almost as though this legislation has been put through without a detailed understanding of what the legal profession does, as though we are banks, and we are not. And we have a completely different raft of obligations and responsibilities, and we're officers of the court, and that just seems to have gone through to the keeper. So what do you have to do if you are caught by the regime? You've got to enrol with AUSTRAC. Start enrolling with AUSTRAC on the 1st of March. And there's a bit of fanfare around that too. It's not necessarily as easy as it could be, but Fiona will tell you a bit more about that. You have to undertake a risk assessment in relation to every client. Every instruction has to have a risk assessment in relation to the client. You need to work out whether the risk attached to the client, and what the client has to do is, you know, if it's low, medium or high. How do you work out that? I'm not sure, but AUSTRAC's going to give us guidance about it, thank God. You have to develop, maintain and comply with an AML CTF program. We are going to get a draft program from AUSTRAC sometime during the course of this year, which will give people some guidance about how to do that. Then there's the whole raft of due diligence that you have to undertake before you undertake a designated service. And the due diligence is, there's lots of different due diligences, aren't there? There's initial due diligence, there's simple due diligence, there's ongoing customer due diligence, there's personnel due diligence, there's enhanced customer due diligence. And they've all got different thresholds and different levels, and now they'll all kick in at different places. None of this is simple or straightforward. You have to make and retain records for 7 years. That's a particular problem for the barristers, because what do? They shoot their brief back as soon as they're finished. Most of them don't even keep copies of their fee notes, and they don't actually have anywhere to store 7 years worth of records. So things like that. You have to make and retain records for so you've got to report cash transactions over 10K. As I said, there's that interim period where everybody kept that a big secret. You've got to report suspicious matters, and you've got to comply with notices from AUSTRAC. And this is a nasty one as well, because you can't tell your client, if you receive a notice to produce documents from AUSTRAC, you can't tell your client. And that means you then have to produce documents and make decisions about whether or not documents are privileged without any instructions and with no retainer, so you can't charge anybody. So what is the suspicious matter obligation? It's in section, next page, please. Yeah, great, thank you. No, back up, sorry. It's in section 41. Where there's a reasonable suspicion of various matters, you must report to AUSTRAC within 3 for most people. or 5 for lawyers if there are privilege issues of becoming aware of the matter. And it's where there's a question about a person's identity, if you think that the person's not who they say they are, if you think that the source of funds that they're turning up with has been involved in any way with the crime, or you think that the person might have been committed a crime. Well, yes, I don't like suspicious matter reports, but that was my own reaction. So there is no problem. There's a quite expanded definition of money laundering in the Act. Money laundering is not just what you might think is money laundering. It is actually any kind of financial crime. You look at the definition involved. So they're trying to get hold of any predicate crime as well. But there's also an expansive provision in section 41 F1 F3, which says that this provision that says that if you suspect that something that you know has become, it may be relevant to an investigation of any offence under a Commonwealth, State or Territory Act, you have to report. That is very wide provision. It's actually much wider than the FATF recommendation. So it's an example of where our Act has gone further than what is required of the rest of the world. The exemption, as I said earlier, is for material that is legally privileged or legal professional privileged. But the significant problem is what happens if you do report. Can you then continue acting for the client? The Law Council's view, or at least the view of the Professional Ethics Committee of Law Council, is that you cannot continue to act, because to continue to act would breach a whole raft of different obligations in relation to fidelity and loyalty, confidentiality and the like. So any one of the duties under the solicitor's conducts rules would be breached. Even though this might be mandated by legislation, the next part of the equation is basically, were you to continue to act? It's a bit like turning you into, putting you in the same case as the lawyer X case, because once you've filed an SMR, you're liable to get a notice from AUSTRAC. Tell us a bit more about it. Produce some documents. And that might be ongoing. The client might be continuing to give you documents that then might be subject to a notice. So it actually becomes quite untenable. And that's got some real ethical problems, because how do you get out of a retainer? There are only limited ways that you can actually stop acting for a client. We're not like a bank. We can't just boot people out. You have limited circumstances where you can actually terminate a retainer under our rules. So one of the things that Law Council is talking about doing now is changing the rules to make clearer that, one, you have to include in your retainers a provision that says to the client, I am subject to legislation which may require me to report on you. I may not be able to tell you about it, and, that's what I'm going to do. So there's a series of those kind of provisions that are being prepared at the moment, and then they'll have to go through the rules amendment process. But it seems to us that that's really, at the moment, the only way that we can think of through this mess. So that is suspicious matter reporting. Now, tipping off. So, as I said, if this is an offence to disclose to anyone other than an AUSTRAC official. Oh, and by the way, AUSTRAC, when they get material in in a suspicious matter report, they don't just keep it. They're actually distributing it to the federal police, the state police, crime commissions, you name it, they get it. And it can be passed overseas as well. So AUSTRAC regards itself as a channel for communicating information about criminals to anybody who might be interested in criminal enforcement. So they take this suspicious matter reporting very seriously, and it's a criminal breaching the tipping off provisions is a criminal offence. So we can't do it. There are very limited defences. In theory, if you are dissuading a client from committing an act that might be over the line, that may not be tipping off, but you'd have to be awfully careful about how you did it. And there's information in the Explanatory Memorandum which is inconsistent with the Act about how that would be done. AUSTRAC has recognised that we need specific rules. As legal practitioners, we need specific rules around this. They issued some guidance a little earlier that really was focusing on banks. And it basically said, well, you can get around this particular problem by saying to a customer, you no longer fall within my risk appetite, or something like that. I actually have said to AUSTRAC on a number of occasions and to the Attorney General's department, that's very interesting, but I actually don't have a risk appetite. What I have is duties and obligations to the court. So that's what I have to comply with. And I can't say to a client, no, you're outside my risk appetite. So I think they've now recognised that that's correct. The Professional Ethics Committee of Law Counsel is also completely unequivocal that we cannot tell half-truths to clients. So that's why it's important that the up front the retainer is crafted so that it's disclosed to the client up front that we may have obligations that we can't tell them about. So that's a little bit about tipping off. Let me now go to let's skip privilege because I think we've already dealt with that. And then the exemptions. So there's these two kinds of exemptions. Rules-based exemptions, which have general application, and exemptions that operate as a legislative amendment. They're only granted in certain circumstances, and AUSTRAC has to be satisfied, and it has no power to do it unless they are satisfied that the AML CTF risk is low. So what we're trying to do is go through with AUSTRAC that process of working out how to get some of this stuff exempted. Next slide. This is a beauty. The interaction with the Privacy Act. This was a nasty surprise. This is like the act that keeps on giving. Once you become a reporting entity under the AML CTF Act, you also lose the benefit of the small business exemption under the Privacy Act and become subject to the Privacy Act regime as well. They didn't tell us that. And there wasn't anything really in the Explanatory Memorandum that made that clear until the Law Society of New South Wales picked it up. And basically since then it's been, oh my God, this needs to be sorted. And in fact, I'm meeting with AUSTRAC, AGD and the OAIC next week, because what we said is people need guidance about this. They need to know what they have to do. One of the key issues will be, if you think you're going to have a streamlined practice where you just do the same CDD on everybody, when they come into the firm. Well, that might not be right. Maybe you can only do the streamlined practice. You can only do that particular kind of CDD if you undertaking a designated service, and you might not be undertaking a designated service, in which case the Privacy Act exemption would still apply, and you can't, so it's that kind of mess we're now trying to sort through. And we've said to government, and I've written to the Minister of Home Affairs, Tony Burke, and to the Attorney General, and said this needs to be sorted so that the profession knows what they're supposed to be doing. So hopefully that will all get sorted through. Now, what's happening now? Austrac is doing a lot of engagement, is engaging with the profession regularly. I have meetings with them every couple of weeks. They have a lot of working groups and so forth. And they are doing their best to try and get up to speed with what the needs of the profession are and how best to try and get this through without too many disasters. So I give them full marks for effort. At the moment, they are developing this suite of rules, because this legislation is weird. It comes in an act and it comes with rules. So the act is only half of it, the rules is the rest of it. Actually, a lot of the rules that they're now promulgating actually should have been in the act in the first place. It's sort of poor legislative practice to have a lot of requirements and exemptions set out in a different legislative instrument. So there's rounds of industry consultation going on about the rules. The latest draft, I think, shows that I think they've listened to us on a couple of things. First of all, in relation to e-conveyancing, we have said to them, look, you're imposing all these obligations under the Act, and there's lots of people involved in an e-conveyance. It's ridiculous to make everybody do the same thing over and over again. It's just costly, and people will end up paying more money. So they're trying to work through a scheme in conjunction with ARNEC where that won't happen for e-conveyancing. So that's really good. The other thing that we managed to convince them of is that really the money laundering risk in relation to real property happens when the property gets settled, not beforehand. So actually, provided that all of your customer due diligence is done by that point, you should be right. So you shouldn't have to do all of your customer due diligence, et cetera, before you start doing a conveyancing transaction, so long as it's all done by the time the transaction settles. They've accepted that, which is good. That will help with, for example, things like auctions, where people can't get full customer due diligence on people because, someone might rock up and say, I need a contract, and the auction's in half an hour. And you don't know who's going to be on the other, who's going to be the buyer until the fall of the hammer. So that they recognised was a legitimate problem, and the rules are going to be addressing that. They are also developing a whole lot of guidance, but unfortunately quite a lot of it is not going to be ready until the end of the year. They are focusing first and foremost, I think, on the banks, because the banks have got real problems complying with some of the very detailed technical provisions that are now in the Act in relation to transfers of values, in particular, credit card systems and transfers of value overseas and the like. And the bank's current computer systems are not equipped to deal with it, so they have to enhance them. Anybody who's ever done an enhancement project on a computer system will know that that is a lengthy and time-consuming task. So the banks can't start it until they actually know what they're supposed to do. So we are sort of a bit further down the back of the bus on that front. So what are we continuing to do? Advocacy. I'm in these people's ear all the time. as I said, we've had some important wins, but there are many things that we really have to still sort out. We have developed a suite of guidance notes and educational material about exposure to MLTF risks for the profession. And that does include some red flags for what does money laundering look like. And we've got a list which we've pulled together from international material that set out, you know, if you see something that's unusual about a transaction, what's unusual about the transaction, it doesn't sort of seem to have any kind of economic benefit. Why is this being done? That kind of thing. So that was all done before the act was pushed through, and we will update all of that in due course, but a bit further down the track when we actually know what the legislative regime is actually going to look like. It's still a way to go. So our current focus is on trying to secure necessary exemptions and clarify aspects of the legislation. And if I could have, yeah, I think that's, so, and you know, so I've talked about what is assisting a person mean, and what is required where a matter starts out involving the provision of a non-designated service, but it morphs into a designated service. What do you do there? And what's required where another entity has already undertaken CDD. So quite a lot of stuff is underway, and I anticipate being very busy for at least the next 6 months. So that's all from me, and Fiona's going to take a deeper dive into some of these gripping issues.
Fascinating. I mean, such a lot of work you've done.
It's been busy.
It's just enormous. So this afternoon, I'm going to talk more in terms of more about practical issues, in terms of, because what we have is the Act has passed. It's going to happen. This time next year, it's really all going to be on. So I'm going to talk about a number of issues there. Just it's very helpful if I could control for the slides. All right, so I'm talking about a few different things, okay, in respect of AML officers, policies and procedures, independent reviews, training, and also I'm going to briefly talk about the resources that that AUSTRAC is going to provide, which we're hopeful will be effective. So before we go on, can I get an indication of who in the room is? I'm going to ask who's in a small firm, who's in a large firm, and who's a barrister. That will give you a more idea of who's interested in what. So may I start with who's in a small firm? Okay. Who's in a large firm? Okay. And barristers? Okay. All right. All right. Well, small firms, lots more. So, which numerically is what effectively is going to happen. So the vast number of reporting entities under this new regime are going to be small firms, which means that we are, lots of us are really small businesses. We're a small firm. We look at this and we think that this, once you understand what's going to be required here, it looks like a mountain in front of you in terms of what we will need to do. I just put it in that context. I don't mean to be particularly frightening, but there's a lot to do, and there's a lot to understand. That said, the question of what exactly is going to be a designated service, it seems from AUSTRAC as though we're seriously not going to have good guidance on that until December. What that means is the whole regime is completely determined on whether you provide a designated service or not. We think that there are small firms who will not be providing designated services. And they will be thinking, well, do I do this or not? And in a way, there's many small firms that in the next few months, by all means, be reading around about AML because it's more interesting than you might think. There's it is actually there is actually quite a lot of interest to it. If you think about the fact that when you think about television programs, an awful lot of them are about crime. And the reason for that is crime is interesting. And money laundering is interesting. And there's a lot of new books out on money laundering. I've noticed that all the ones I have red covers. I'm not sure why that is, but they all do. And they are much more interesting than my other law books to read, for sure. So I'm going to talk about just basic things here about what we'll need to do. So one of the things is if you're providing designated services, you become a reporting entity, okay, which means you have to be rolled. Okay, so that's absolutely fundamental to it all. One of the things you have to do is you have to have an AML officer, okay, and this AML officer you must be employed or otherwise engaged by the reporting entity at a management level. So it's got to be someone who's at a relatively senior period. But interestingly, it doesn't have to be at the top of the organisation. The Act draws a distinction in different places between management level and senior management. So the question, I've had people say to me, is it enough to be a senior secretary? I think that's a bit not enough, okay? But someone who is at a decision-making level in the firm. However, that person is going to have enough information about AML to be able to effectively monitor behaviour. And I think there's a massive jump in learning for someone to get to that point. But they must have sufficient authority, independence, and access to resources and information to carry out their functions. I think what we'll find that in small businesses, which is going to be most of the reporting entities, that we'll find that there will be as partners, directors, I think somebody within the firm is going to take it on. But the other possibility is that the Act, by the use of the words employed or otherwise engaged, does countenance the concept that there might be contractors who will provide this service. And that's one of the things that we've seen in the ASIC regime. So with AFSL, there's been a requirement for a responsible, they're called a responsible manager now. They used to be an officer, but they've changed it. And there's plenty of those people out there who put themselves out for hire. And in fact, there were some who were doing it so successfully that ASIC had to stop them because they had so many entities that they were acting for. And so we're expecting that there'll be a range of these people who will do this. Whether you want to pay these people to do it will be a different question. So I think there'll be a few different options in respect to that. But there are quite a lot of functions for that officer. They have to oversee day-to-day compliance, they have to communicate with AUSTRAC, etc. That is interesting about that role, which has been surprising to me, has been that the role doesn't have nearly as much liability as I thought it would. So someone asked me about that last week and I still wouldn't want to do it. I think that's probably true. But if you look at some of the US cases, you've got some cases where there is a case in the US where someone has been fined $400 million as a responsible officer. Okay, but the liability under the Act for ROs here seems to be quite a lot lower. But unfortunately for most of you who are sitting here, that means that liability has moved up to what's called the governing body, which is going to be directors, okay, for the partnership. So not necessarily good news for all of you. Now, okay. Sorry. Policies and procedures. Okay. Now, this is going to become an area that you will become very skilled in. Okay. And policies and procedures form much of the base of the regime. So we have the legislation, and I'm using the legislation word in a really broad sense to cover the Act, rules, regs, everything. And that effectively requires that you have these policies. Okay? And then you are assessed as to whether, and the policies, what is required to be in the policies is set out in the legislation. And then you are assessed according to whether you follow your policies. Okay? And so you need to do that. And there's AUSTRAC is saying that it's going to be putting out these starter packs, and we're expecting that they will contain some template type policies for you. There are an awful lot of people who are internationally seeing Australia as a complete feeding frenzy for the service providers of AML services. Okay, they are just out there marketing like mad. Okay, they will tell you that they have got a set of policies that you can have. It's all very wonderful. You haven't really lived until you've been in a compulsory examination with a regulator, and your client and the regulator has collected all of the materials in advance to grill your client often for days on end, and they are asking them about their policies, and they put forward the document which your client has said is the policies, and they open it, and it's full of non-replaced variables within the document. Okay, and you haven't really lived until you've tried to do that, and that is the kind of thing that is going to happen if people are buying templates off the shelf. Okay? So I would strongly encourage you to think about the policies, whatever policies you have. You can't just buy them from someone. Okay, you are going to have to live them, okay? And you are assessed as to whether you are living them. So
I just said one thing at this point.
Do.
AUSTRAC has asked us to communicate to people that they don't want people going out and buying stuff now or engaging with the feeding frenzy now, because the feeding frenzy is not in a position to give informed advice about what the regime will actually look like at the end of the day, because even AUSTRAC doesn't know yet. So no to anybody who's trying to get you to open your wallet for them.
Very good advice. That's exactly correct. We think it's far too early. AUSTRAC says it's far too early. So, but you will come to have to develop these policies. The other interesting thing is that AUSTRAC can actually require you to have new policies if it doesn't like them. So they can do that, and that will always be interesting. In order to keep you walking the straight line, okay, at least every 3 years you have to have an independent evaluation. And I'm sorry, I wrote review here, and I should have written evaluation. Now this is very different. I draw a distinction here between these evaluations and audits. Okay, two different concepts. Okay, but the independent evaluations have to be carried out, and this is going to be a whole new area of work for people, because these people, apparently, we don't have all the guidance we need on this yet. There's some that we've seen, but we can't talk about yet under the secret squirrel arrangement, and that is. It looks as though you're going to have somebody who knows something about AML in order to do this evaluation. And they think they're going to need between 3,000 and 4,000 of these people, of which there are currently probably about 2. I think that's about right. So, but this evaluation is going to happen every 3 years. Okay. So it'll be kind of interesting to see, how that can happen. The legislation does countenance the idea that it can be an internal person who can do the audit. Okay, but I'm absolutely struggling as to how that's going to work, because you think even if you think about a really quite a large firm, okay, the evaluator has to be completely independent. They can't have had anything to do with developing the policies. They can't have anything to do with the work areas being evaluated. So I cannot see how you can have an independent evaluator in this process. So there'll definitely be a whole lot of those new things. But there is also a concept of an external auditor, where AUSTRAC can require a reporting entity. I keep wanting to say responsible entity from the Corps Act, but it's a reporting entity to appoint an external auditor to carry out an external audit. And this seems to me very similar to the independent expert that ASIC can require you to appoint. And that's always been actually usually part of the punishment with ASIC has been having to pay for the independent expert. So in terms of how often, every 3 years or less, according to how complex things, who can provide the review, we still don't know. What will be reviewed? They will be evaluating the design of your program, okay, whether you are sticking with that, whether you're doing what you say you will, whether you are properly assessing your money laundering and terrorism financing risks, that kind of, so very broad, I'd expect. Ongoing obligations, training. Okay, training is absolutely massive under this new regime. It's stressed almost everywhere, and you will probably find that you need to have training I think you will need training for almost everyone in the firm, probably except the cleaner. But I think you will have to, and I think you're going to have different levels of training. So I think you'll have training for the people who are involved with file opening. You'll have training for, you have to have training for all client-facing staff doing any professional work, because they need to see if there's something that's being picked up, because it's all about seeing these odd transactions. And then you'll need to have training for your governing body. So there's, and obviously lots of training for the AML officer. So there's going to be, as far as I can see, at least 4 sets of different training that's going to continue, that's going to be going on. And it must be done at the time that the person is engaged by you, and also on an ongoing basis. Okay, so I think you're going to be looking at, definitely think you're going to be looking at annual refresher training for everyone. I hope this isn't making everyone feel really depressed, but it is what's going to happen. And then we're going to talk about, looking at what AUSTRAC is going to provide. And AUSTRAC is saying that it's going to provide these starter packs. Okay? And we're very interested in this idea. They do have an awareness, with some AUSTRAC people have an awareness of the costs that we're talking about for small business here. There are some AUSTRAC people who just don't care, but there are others who really do care. And they are concerned to ensure that there is material out there that you can use as a base. And we are expecting that there will be these starter kits. And we're expecting that those starter kits are going to involve, at least a good guide and a template for doing a risk assessment. They'll give you a starting pack of policies. And they are currently working on training at the moment. They've put up 10 e-learning modules. Okay, so they're available. They're free. And they've got the government, obviously it's the government's version of things, so you'd expect to be in line. I think there's likely to be a huge advantage from using the AUSTRAC starter kits if you can, and they will be out before Christmas apparently. If you can start with an AUSTRAC starter kit, okay, and if these kits are okay, then what that would mean is it would mean that you'd expect then your systems to fit relatively well with AUSTRAC systems. And that seems to me to be a really big advantage if that occurs in that way. We hope it's not like ASIC's. So ASIC decided that it was tired of financial planners producing very lengthy statements of advice, and you can understand that concern because there's quite a lot of statements of advice were topping the 100 pages. And ASIC decided that it was going to produce a model statement of advice that planners could use. Came up with something with 9 pages, and it was completely unworkable. So we are hoping very much that we don't end up with something like that. And we're hoping that this starter pack does end up being something more practical. The indications are hopeful at the moment, but it will, only time will tell on that one. Before I go, so nobody feels incredibly depressed by this, the penalties that AUSTRAC has levied on smaller firms in the last couple of years are much, much lower. We are, for the kind of firms that, from the numbers of people who put their hand up as small here, the penalties are really between $10,000 and $20,000. Okay, so don't be too distressed. And the final thing is the reason that AUSTRAC penalties are so amazing, and Juliana, you will have definitely run into this, is that every day you don't do something is another contravention. Okay, so if you're supposed to have an AML officer, okay, and you're supposed to have that, you're supposed to appoint your AML officer within 28 days of providing designated service. Okay, all right. Well, if you don't, okay, day 29, ka-ching. Day 30, ka-ching. Day 31, ka-ching. And that's how these things, this is how these amazing penalties have occurred, but it also is an important indicator that it's a good idea to get your house in order, because you don't want things that you're supposed to do sitting there for a long time undone, because it will come back to bite you in spades. Okay. All right, I thought, right. This is the sorry, no, me too. I'm not sure I'm doing this slide.
Oh, yeah.
Yeah.
Well, we've got
Okay.
15 minutes left, so if we can go to questions,
Perfect.
I think that would work well.
Okay, great. All right, so this is just here to give you some idea of timing. Okay, and that so just some kind of structure around the time. Okay, good.
Just going to move over so I'm not sat in the lap again. So two very quick questions from me to start, and then we'll go to the room. We all need to comply and be registered by 1st of July next year. And the window for registration opens at the end of March. And the advice at the moment is get your application in, because this is not a rubber stamping exercise. Your application may be assessed and you can't do any transactional work until that, you've got that registration. So if we need to all be in order with our policies and everything by the end of March and have our staffing resources in place, but we're still waiting until December to know what the guidance and the rules are, that gives us a very short window at the beginning of next year to all scramble about to comply. So what do we do now while we're waiting for AUSTRAC to gaze at its navel and come up with the answers
Well, this is what
to
I'm
get
trying-
us ready?
This is what I'm trying to hassle them about. Well, at least work out what these designated services are. Tell us what assisting means. You have to be able to work this out. You don't have to wait until the end of the year. You must have had a view when the legislation was passed. You put the words in there. So tell us what you think they mean. And that is really a relevant question to be answered for things like the legal assistance sector. Legal aid commissions may be covered by this regime because they do family law, and they also do things like small property transactions, granny flats, that well-known flag for money laundering. You know, they deal with those kind of things. And to expect a legal aid commission that is dealing with the most vulnerable and the poorest of the poor, basically, to have to do AML CTF compliance is just ridiculous. So one of the things I have been arguing with AUSTRAC about is getting an exemption for the legal aid sector. They sort of are sympathetic, but they're trying to work out if they can use this definition of assisting in some way to define, the impact of the regime out of the purview of legal aid sectors. So it's got some real practical problems.
Yeah. And is there anything practically we can do, Fiona, if we go back to our desk right now, which I hope no one's about to do, what can we do today to
We need
get
to learn
started?
about what money laundering looks like, in my view.
I think that's a good idea.
Yep.
That's absolutely it. There's starting to be a ton of information out there. So almost all the law societies have materials which are available, and the Law Council has materials as well. As I said, AUSTRAC has got materials. And we're starting to be deluged with information. It's probably getting a bit late towards the end of the year, but it wouldn't be a bad idea to put some money in the budget for next year for it. If you're thinking about it, I think that you will find that you will probably have to spend a bit of money on consultants and that kind of thing. There's different rounds in terms of that with AUSTRAC, in terms of numbers. Some are very low, some are quite high. But you might not think that you might want to put a bit of money aside for this. It can happen. And also, I think that if you are a firm principal, my expectation is that you might be doing some reading over Christmas.
And I should say that the WA Law Society's AML Hub will be going live in the next few days with what we know so far, but obviously that will have to grow over the next 12 months. And my other question was around the international stage, which you opened with, Juliana. We're not the first country to do this. The UK's had a regime for decades. New Zealand has gone through the bumps and lumps, and places like Canada we can be learning from.
What's going on?
Have we learned from these jurisdictions?
Canada doesn't have a suspicious matter reporting regime because under the Canadian Constitution, suspicious matter reporting on your clients is unconstitutional. And it got knocked out in 2015 in a Supreme Court Canada matter. Nevertheless, what the Canadians did was the Federated Law Societies, Canada, put in place rules that basically reflected compliance regime. So the equivalent of an AML CTF compliance regime without the suspicious matter reporting thing. Now, they are coming up for FATF evaluation at the end of this year, and I had a meeting with them a few weeks ago, and they were talking about getting their government on side to argue with FATF that their regime was pretty good and that FATF should sort of tick them off. And so they're hopeful. The New Zealanders had a very bumpy time of it. I mean, even Austrac has said to me that New Zealand is the high watermark of what not to do, which was entertaining. You had different views from people about whether practices got knocked out or they didn't get knocked out, or it was just older practitioners who were just retiring because they didn't want to get up to speed with the new framework or whatever. But anyway, you cut it. AML compliance, the current Law Society president of New Zealand says that when he goes around and talks to practitioners, the biggest concern they have is AML compliance and how to deal with it. It's a big issue. The UK system is slightly different to ours. There's a more restricted suspicious matter reporting obligation, and they have a broader definition of privilege. So that is not exactly equivalent. But, I mean, at the end of the day, we're just going to have to get on with it, frankly, and try and knock the bumps off as best we can, and see how it goes. I mean, it really should be reevaluated in a few years' time to see exactly how much it's cost. I mean, we don't actually know how much this is going to cost. There was some financial analysis that was done by the government, which sort of said for small firms it was likely to be, I can't remember the exact figures, but it was around 20.
If your turnover was $1 million, they were expecting that your costs on an annual basis would be around 28,000.
Yeah.
Which I thought was ridiculous.
Yeah.
And,
yeah. There's a lot of firms that don't have turnover of $1 million.
Yeah.
I mean, I suspect it's going to be around the same kind of cost as your PR cost.
On that happy note, any questions from the floor?
I've got a couple of questions and a tip. First of all, the draft rules, are there any in circulation, or is it only secret squirrel stuff at the moment?
No,
the rules are public. There's an exposure draft of the rules. The draft guidance that they have put out on the program, though, that's secret squirrel.
Right.
Which is they keep doing this, and we keep saying this is hopeless because we've got to go back and consult with people.
Yeah. So we should be able to do a Google search and find the rules somewhere.
Should be able to find the draft rules somewhere.
I understand you're meant to identify the beneficiaries, trusts and things. What happens with a family trust?
Yeah.
Where you've got cascading
There's
beneficiaries. Do you need to go?
There's
How
something
far
in
do
the
you need to
rules
go?
Well, there's something in the rules that talks in the draft rules that have come out that talks about describing a class of beneficiaries if you can't exactly identify.
So you'd have to identify the appointors and guardians and the trustees and the directors of the companies.
You definitely set as appointors, trustees, anyone with control.
Yeah.
I just wanted to get an idea of what's involved with the client due diligence aspect, and then also, is that for each matter? So if I'm got a client that's going to instruct me more than once, do I have to engage in that client due diligence each time?
There's something in the rules that I just saw this afternoon that suggests that you might not have to, but I wouldn't take that at my word yet until that rule's finalised. I think they are trying to accommodate things like that,
There is
So we don't know.
but we don't know.
we would expect there will be there's an ongoing due diligence requirement.
Yeah.
Okay, so you would expect, for example, you've had a client who has been owned by another people, and suddenly it's it's bought by another group of people. Okay, and that second group of people, you would expect to have to do new due diligence in respect of who those new owners are. And you'd expect that if you had particular suspicions about that you might have to do enhanced due diligence about it. So your consistent corporate client, although it's the same entity, if the people behind it are changing, you'd expect you to do ongoing due diligence.
Sorry, we had this one here first.
A very specific question. Does the definition of real estate include mining tenements? Do we have any clarity around what real estate means?
I'm not sure, to tell you the truth. I'd be surprised if it didn't.
Yeah.
It includes foreign land, I know that. I looked at that recently.
Yeah.
It's very, very broadly drafted.
Yeah.
I think
Any interest in land.
Sorry, just the level of due diligence required and the enhanced due diligence and that sort of stuff. There was no discussion today about politically exposed persons and sources of wealth.
Oh, yeah.
And well,
I am a PEP, believe it or not. And the reason I am a PEP is because I am a member of the Legal Services Council, which makes rules for the legal profession.
and then it picks up
So how much of a money laundering risk is that?
and then it picks up family members and stuff
Yeah,
like that.
and all my family.
So my question is, how, especially small firms, are supposed to undertake that level of due diligence when you've got layers of companies, trusts, nominee shareholder? I mean, it is a
quite,
huge task.
it is quite,
And it would take forever, and you probably won't get the right answer.
and you probably won't get the right answer. And I think, at the end of the day, if you're making reasonable endeavours to do it,
Right.
it's hard to see that you, but you fail. It's hard to see that you're going to get pinged for it, but you never know. I mean, it's difficult.
The other thing is the steps that you're required to take are based upon your risk assessment, both of your overall business
Yes.
and of that particular client. Okay, so if you have a firm which does a whole lot of transfers, there was a whole lot of transactions with people from countries that are seen as money laundering countries, then you would expect to have a high risk assessment, and you would expect to then undertake more detailed procedures and a much greater level of due diligence. If, however, you were a firm that didn't do that, maybe in Wheatbelt or somewhere. I'm just thinking of somewhere where you'd know everyone and you'd feel that you had a very low level of risk there, that kind of thing, then your procedures might be much less.
But then there's the question of, what are the red flag areas? I mean, I've seen North Korea and Iran on the list, but there are other countries, Pacific Islands and so on, which are pretty...
there are other countries. I mean, this is why you have to educate yourself on what is money laundering. And I think, we could all do with some courses on straightforward, this is what money laundering looks like.
Yeah. And that is what's out there at the moment that we can safely know is not going to change in the next few months.
Yeah.
Anyone else?
So it's a lot to learn.
Yeah, sorry.
The DD process, I assume, is heavily reliant on client interaction, what they tell you, rather than third-party interaction. if they don't tell you anything, are you able to act, or what are you supposed to do, or is that in itself suspicious?
Well, if you have an immediate suspicious matter reporting obligation if you suspect that the person in front of you is not who they say they are.
I mean, I'm not saying any of that. So I assume as part of this DD process, there'll be a standardised set of questions or processes that you'll have to ask a client.
Yeah.
8 out of 10 clients are going to ignore it. Right. Just will. Yeah. Until you follow them up.
Well,
Yeah. And so what do you do while they're ignoring it? Do you not work on the matter?
You're not expected to rely on what your clients tell you. You are expected to do third-party searching. You are not expected to rely on entirely on what they tell you. You are expected to do a level of verification, and if you're not doing any of that, you will have a serious problem when it comes to your independent evaluation.
But the other thing is this. I mean, clients are used to providing the kind of information that we are going to have to be getting from them to their banks. You know, it's sort of like, I'm not asking you for any secret stuff. I'm asking you for the same information that you've given to your bank. So you actually have to, which does actually raise another point. As lawyers, and we've always sort of taken the view that the best way to develop your firm and your business as a lawyer is to know your client and understand their business. Well, under this Act, we have an absolute obligation to understand the business of our clients, not just the particular transaction that they're doing, but the actual business, because AUSTRAC says you can't assess what the transaction is or whether it's got money laundering risk unless you understand it against the framework of what the business is actually doing. So you're going to have to ask lots of questions. They're going to have to answer lots of questions. It's going to be time consuming. This is one of the reasons why this is going to be costly, because you can't just get stuck in. And I think clients will just have to come to terms with it, because at the end of the day, any lawyer they go to is going to have to ask the same questions.
But
if you're doing a designated service.
On the suspicious matter reporting, as I understand what you said earlier, that if we've got a suspicion, we've got to report it, and then we can't tell anybody that we reported it.
Yep.
Is there an obligation on us to tell a client before we get to that stage? But if you do anything, that it leads me to that conclusion, I'm under an obligation to do a suspicious matter report. Because I'm very concerned about this whole thing of client relationship here. But
I'm not sure that AUSTRAC would be happy about that. That's why when I said we were changing the rules, or we were putting in progress of a means of doing that, we are going to have to clear that with AUSTRAC, because the last thing we want is to have something embedded in our rules that AUSTRAC then turns around in 18 months' time and said, well, that actually amounts to tipping off the people who are doing that.
But even before you tip,
you do have to. We always have an obligation to ensure that clients understand that they cannot engage in unlawful transactions, and we can't facilitate unlawful transactions. And
there is an exception in relation to counselling. There is an exception in relation to counselling. Not to engage.
Yeah, you can counsel people not to engage in certain kinds of transactions. Tax lawyers have this problem all the time when they're trying to advise about what's evasion and what's appropriate.
Well, on that note, I think we all have a big drink. But Juliana and Fiona will be around for a little while, and please help yourself to refreshments. Again, if anybody wanted to keep their questions confidential, I don't think there was anything particularly controversial there, but if you do, just let me or a Law Society staff member know. And please join me in thanking our speakers for today.